Good day everyone. I am student 48, Rizar Napitan, and I'll be talking about the 2016 Revised Implementing Rules and Regulation of Republic Act No. 9184, otherwise known as the Government Procurement Reform Act from Section 57 to Section 63. Here are the list of sections to be tackled. Section 57, the non-interruption of the bidding process. Section 58, resort to regular courts. Section 59, arbitration. Section 60, appeals. Section 61, contract prices. Section 62, warranty. And lastly, the Section 63, organizations and functions. In Section 57, the non-interruption of the bidding process, the bidding shall not delayed and cancelled. However, if there are protests been made, it must be resolved before the awarding. So here comes the Section 58, in which the protest has been not yet resolved. So in Section 58, resort to regular courts. In Section 58.1, court action may be resorted to only after the protest contemplated in this rule shall have been completed, for example, resolved by the Hope with finality. The regional trial court shall have jurisdiction over the final decision of the Hope. The Hope has the authority, if he or she deems necessary, to exercise the reservation clause under Section 41 of RA 9184. Grants the Hope the right not to award the contract if, for any justifiable and reasonable ground, the award of the contract will not redound with the benefit of the GOP. In Section 58.2, this provision is without prejudice to any law conferring on the Supreme Court the sole jurisdiction to issue temporary restraining orders and injustice relating to infrastructure projects of the GOP. In Section 58.3, the head of the BAC's Secretariat, the procuring entity concerned, shall ensure that the GPPB shall be furnished a copy of the case filed in accordance with this section. Rule 18. Settlement of disputes. Section 59. Arbitration. Arbitration is a procedure in which a dispute is submitted by agreement of the parties to one or more arbitrators to make a bidding decision on the dispute. In Section 59.1, if any dispute or difference of any kind whatsoever shall arise between the parties in the connection with the implementation of the contract covered by the Act and this IRR, the parties shall make every effort to resolve amicably dispute or difference by mutual consultation. In Section 59.2, any and all dispute arising from the implementation, that by mutual agreement the parties may agree in writing to resolve other alternative modes of dispute resolution. Section 60. Appeals. The arbitral award and any decision rendered in accordance with the foregoing section shall be appealable by a way of petition for review to the Court of Appeals. The petition shall raise pure questions of law and shall govern by the rule of the courts. Rule 19. Contract prices and warranties. Section 61. Contract prices. In Section 61.1, all bid prices shall be considered as fixed price and therefore not subjected to price adjustment and escalation during contract implementation. In 61.2, a contract price adjustment shall be made or appropriate relief shall be applied on a no-loss gain basis. In 61.3, any request for price escalation under extraordinary circumstances shall be submitted by the concerned entity of the National Economic and Development Authority, or also known as NEDA. In Section 61.4, contracts shall be denominated and payable in Philippine currency. So if you have a US dollar, you need to convert it into Philippine currency. In Section 61.1, for the procurement of goods, in order to assure the manufacturing defects shall be corrected by the supplier. A warranty security shall be required for a contract awardee for a minimum of 3 months in the case of expendable supplies, or a minimum of 1 year in case of non-expandable supplies after acceptable by the procuring entity of the delivery of the supplies. Section 62.2.1 From the time project consultation commenced up to final acceptance, the contractor shall assume full responsibility for the following. A. Any damage or destruction of the work except those occasioned by force majeure. And B. Safety, protection, security, and convenience of his personnel, third parties, and the public at large, as well as the work equipment, installation, and the likes like to be affected by his construction work. In Section 62.2.2, 1 year from the project completion up to the final acceptance or the defects liability period. In Section 62.2.2.1, the contractor shall undertake the repair works at his own expense of any damage to the infrastructure on account of the use of materials or inferior quality within 90 days from the time the Hope has issued an order to undertake repair. In Section 62.2.2.2, the defects liability period shall be covered by the performance security of the contractor. In Section 62.2.2.1 of this IRR, the procuring entity shall forfeit its performance security, subject its property to attachment or garnishment proceeding that perpetually disqualify it from participating in any competitive bidding. All payables of the GOP in his favor shall be offset to recover the cost. In Section 62.2.3, from final acceptance of the project up to the period prescribed in Section 62.2.3.2 of this IRR. In Section 62.2.3.1, the following shall be held responsible for structural defects. For example, major faults, flaws, deficiency in one or more structural elements of the project, which may lead to structural failure to completed elements or structural failures. For example, where one or more key structural elements in an infrastructure facility fails or collapse, thereby rendering the facility of part thereof incapable of withstanding the design loads and or endangering the safety of the users or the general public. So first, the contractors would be held liable to the use of inferior quality or substandard materials and any violation of contract plans and specification. B. Consultants. Consultants will be held liable as arise due to the fault and or inadequate design specification as well as construction supervision than the consultants who prepared the design or undertook construction supervision for the project. C. Procuring entities representative, project manager, construction manager, and supervisor shall be held liable in case where the structural defects or failures are due to his or their willful intervention in altering the design and other specification. D. Third parties. Third parties are held liable in cases where structural defects or failures are caused by work undertaken by them, such as leaking pipes, diggings or excavation, underground cables, electrical wires, underground tunnels, mining shaft, and the likes, in which case applicable warranties to such structure should be levied to the parties for their construction or restoration works. And lastly, the users. Users shall be held liable due to abuse or misuse by the end user or implementing unit of the constructed facility and or non-compliance by a user with the technical design limits and or intended to the purpose of the same. In Section 62.2.3.2, The warranty against structural defects and failure shall cover the following periods from final acceptance, except those occasioned by force majeure. A. Permanent structures. 15 years building of type 4 and 5 is classified under the National Building Code of the Philippines. B. Semi-permanent structures. 5 years building of type 1, 2, and 3 is classified under the National Building Code of the Philippines. And lastly, other structures. 2 years, bailey and wooden bridges, shallow wells, spring developments, and other similar structures. In section 62.2.3.3, to guarantee that the contractor shall perform his responsibilities as prescribed in section 62.2.3.1 of this IRR, shall be required to post a warranty security in accordance with the following schedule. First is the form of warranty security, amount of warranty security. Second, not less than the required percentage of the total contract price, cash or letter of credit issued by a universal, or 5%. And lastly, commercial bank, provided, however, that the letter of the credit shall be confirmed, authenticated by a universal or commercial bank if issued by a foreign bank. In section 62.2.3.4, the warranty security shall be denominated in Philippine peso, remain effective for 1 year from the date issuance of the certificate of the final acceptance by the procuring entity, and return only after the lapse of the said 1 year period. In section 62.2.4, in case of structural defects and failures occurring during the applicable warranty of period provided in section 62.2.3.2, hereof the procuring entity shall undertake the necessary restoration or construction works, shall be entitled to full reimbursement by the parties found to be liable for expenses incurred therein upon demand, without prejudice to the filling of the appropriate administrative, civil, and or criminal charges against responsible persons, as well as forfeited of warranty securities posted in favor of procuring entity. Rule 20. The Government Procurement Policy Board. Section 63. Organization and Functions. In section 63.1, the Government Procurement Policy Board, or the GPPB, as established in section 63 of the Act, shall have the following duties and responsibilities. A. To protect national interests in all matters affecting public procurement, having due regard to the country's regional and international obligations. B. To formulate, amend public procurement policies, rules, and regulations, and amend to whenever necessary. C. To prepare a generic procurement manual, the standard bidding forms of procurement. D. To ensure the proper implementation by procuring entities of the Act, this IRR, and all other relevant rules and regulations pertaining to the public procurement. E. To establish a sustainable training program to develop capacity, government procurement officers and employees, and to ensure conduct of regular procurement training programs by and for procuring entities. And lastly, F. To conduct an annual review of the effectiveness of the Act and recommend any amendments thereto as may be necessary. In section 63.2, the GPPB, or Technical Support Office, which shall provide support in the performance of its duty and responsibilities specified in the Act of this IRR. The TSO shall be attached agency to DBM, shall be under its administrative supervision for general oversight and for budgeting purposes. In section 63.3, the TSO shall provide research, technical administrative support to the GPPB, including: first, a research-based procurement policy, recommendation of the rule drafting. B. Development of updating of general procurement manuals and standard bidding forms. C. management and conduct of training procurement system and procedures. D. Evaluation of effectiveness of the government procurement system, recommendation of improvement systems and procedures. E. Monitoring the compliance of the Act, assisting procuring entities improve their compliance. F. Monitoring implementation and effectiveness of PhilJEPs. And lastly, G. Secretariat support. In Section 63.4, in addition to the power granted under the Act of this IRR, the GPPB shall absorb all the powers, functions, and responsibilities of the Procurement Policy Board created under EO 359. All functions related to procurement policy making of the Infrastructure Committee of the NEDA Board are transferred to GPPB. And that's all for my report from section 57 to 63. Thank you for listening.